somebody sent them to us, where they would like every council or select board to adopt this specific language to put on the ballot. So this is not unique in and of itself. If there is a problem with that language, Ed spent more time. I was the one who said, let's bring it to the council and let's save people from, getting signatures, because I thought I thought the council would support it, and that could save some time for everybody in the community. But you still have to educate everybody in the community. So Ed was the one who actually worked with Ginny to get that language. I didn't really spend a lot of time on that. I just accepted when Ginny said, I feel like we should be speaking with one voice throughout the state. I accepted that. I said, that's a good point. But if you have issues, you have to identify those, and that can be considered. Okay?
Yeah.
All right. Yeah.
So, but there may be time to, if
yes,
people are
there is.
persuaded to adjust the language, maybe they can.
You can make that recommendation. I don't know what the council will do with it, but you can make that recommendation.
But they might vote it down. But
They
at
might.
least
They might.
they hear it,
Yes.
right?
I think Emma wanted to make a change in the language, and Ed cautioned, because he's been counting the noses around the table and support this, and he didn't want to give anyone any reason to bow out from any change. So you can hear what goes on. Okay, so I don't know. All right?
Can you give me a summary of your position on this?
A summary?
Yeah.
Okay, so the Constitution already includes a remedy. It was written in to the Constitution as originally drafted at the Constitutional Convention. And the revolutionaries who wrote the Constitution, they'd overthrown the king. They were very sensitive, or at least the king's rule in the United States. He still ruled in England, but we became an independent country. They were very sensitive to tyranny, and they divided our government into three branches, and they had checks and balances on all three branches. The check on the court is a very good one, and it has been in use ever since the Constitution started, that the court gets its jurisdiction by virtue of Congress giving it jurisdiction over any issue. And that was something in the very first case where, and that is in the Constitution as well, that Congress sets the jurisdiction of the court. It's in Article 3, Section 2. Any constitutional amendment is more text for the Supreme Court to misinterpret. Our problem is not with the Constitution. Our problem is with the court. The court is the one who took the First Amendment and said, well, money is speech, and speech is protected by the First Amendment. They can take any text you want and misinterpret it as a way of giving power to the 1% and disempowering the 99%. So if you make an amendment to the Constitution, you're saying there's something wrong with the Constitution, and you're giving that text to the Supreme Court to misinterpret. What the founders of our country said was, no, if the court is abusing its power, take away its jurisdiction. So they can't even consider the issue and abuse that power. That is the approach that we should be following and urging our legislators to follow.
Okay, so then what's the remedy from a citizen grassroots perspective? What efforts could we engage in to be able to address it through your mechanism?
Much simpler than a constitutional amendment. For a constitutional amendment, we're asking Congress to pass the amendment by a 2/3 majority, and then it goes to the states, where 3/4 of the states have to ratify. For what I'm proposing, we simply ask in Congress, by a simple majority vote, to remove jurisdiction from the court and to remove money from elections, private money from elections, so that there's no, just like in France, no private money in elections. And they can do that with simple majority votes. And actually, Congress has passed laws, and the states have passed laws restricting money in elections. But they've all been overturned by the Supreme Court. Our problem is the court, giving them more text to misinterpret, and actually it legitimizes what they've done already. We're legitimizing them being in this business of making decisions about financing elections. For the first 200 years of our country, the court on its own said that is not an area for the court. They said that's a political question for Congress to decide. It was only beginning in 1976 that the court stepped in to financing elections and other political questions. And this is something that's so long established, it should be reestablished, that political questions are for Congress, conflicts between people or groups of people are for the courts to get into, yes, but not where it involves, and this is the way the court analyzed it in 1803 in Marbury versus Madison, where the court decided that it could declare laws unconstitutional. They also said they're not going to address political questions, things that are at the discretion of the executive, and bills that affect or laws that affect the people as a whole, like elections, how you fund or finance elections.
What would you say is, since like the politicians are the ones who have the most to gain from corporate backing, or like, don't you think that like maybe asking the Congress to repeal this stuff would be unproductive?
Yeah, it's a good question. How are we going to get Congress to do this? An amendment requires Congress to do something.
Yeah.
It requires 2/3 of Congress.
Yeah.
Okay, so a majority is much easier. Simple majority to get them to ask them to revoke, or just use their existing constitutional power is simple majority. Why would we say, okay, we mistrust Congress because they're bought politicians, so let's get 2/3 of them? How does that make sense?
Yeah.
Okay, so if we're looking
Sounds
for...
like it might not work either.
It might not work either way, but with enough public pressure, we have a much better chance with using the existing power provided by the founding fathers of our country, who foresaw abuse from the executive, they saw abuse from the Congress, they saw abuse from the courts, and they put remedies in for each one. We have a separation of powers and checks and balances. To ignore the checks and balances and to go with an amendment is impractical, but it also legitimizes the court being involved in it. And if we legitimize, they should not have been involved in this in the first place. This is keeping elections from being corrupt is an area for Congress to police. And especially where the court's decisions are making elections corrupt. That's what they're doing. They're making it so that you can buy and sell elections. So they have to be removed, or our whole system of democracy is overthrown.
Yeah. And it's important to note that nonprofits, like at least Bernie's amendment, nonprofits aren't excluded. Therefore, it's going to be the same issues. It's like a corporate can just funnel it through a nonprofit, like they have.
This is incredibly dangerous for the American people. And we're getting progressive groups and progressive legislators, progressive senator supporting what is, I think the word dangerous is the right word here, because we're legitimizing the court being involved when in fact it's illegitimate for the court to be involved in political questions. And secondly, we're giving the court more text. They can make more adverse decisions. What do we expect out of this Roberts Court with their 5-person majority? They're never going to relinquish. Once we say to them, yeah, you have the power to decide, why are they going to suddenly turn around and decide for the 99%? We know they're not. They've made these incredibly ridiculous decisions. The idea that corporations should be allowed to spend unlimited amounts of money, that corrupting elections is somehow okay, if only to preserve the right of the viewer of a television program to have that program interrupted by a corporate-sponsored ad for a candidate or for a political viewpoint. So they're kind of hiding it underneath the First Amendment. It's ridiculous. It's not a First Amendment issue. It's a corrupting of our elections and of our democracy issue. And so it's an area that they have shown themselves, this court is our problem. They're the problem, and giving them an amendment only legitimizes the problem of them being involved. We have to find us a way of getting the court out. And that was precisely what the Founding Fathers did. They gave us the mechanism in Article 3, Section 2 of the Constitution. Why should progressives be advocating for anything else than using that power? And it's been used. It's not like some people will say, oh, it's not been used. But it's such settled law that there are cases from the 1800s where it was used, and it's just not even controversial anymore. It never was controversial.
Thank you very much.
Thank you. It's my pleasure.